Welcome to Solid Citizen Legal Encounters. All right, we're continuing with the Saxs case, and I have two hearings for you today. The first hearing is going to be a big twist in this case, and I'm sure you're going to want to know what's going on with that. So check this out, put your comments in, and don't forget, if you like these videos, give it a thumbs up, but it's definitely going to be interesting. Let's go.
Did you see a Zhang? Can I have appearances, please, starting with the people that are in my courtroom?
Dina Renetti for the
And good morning, Your Honor. Ben Bateman, Parliament here to stand by counsel for the defendant.
All right. And then the court will note for the record that the court is actually appearing remotely as this matter was filed on July 18th at 12:03 p.m. And as there is a current calendar call set for, I believe it's August the 12th. I don't have the calendar in front of me, but I believe it's August the 12th. And the court is out of the jurisdiction until August the 5th. I wanted to get this on calendar as soon as possible based on last week's hearing as well. And so we reached out to counsel to see if everybody could be here today. So I apologize that I am not there in person, but I was already going to be out of the jurisdiction when this motion was filed. And I thought based on the fact that I know what's going on in this case and I'm up to speed, that it would be better heard by myself than heard by anybody else that is subbing in for me. All right, can I get appearances for the people that are on Zoom right now, please?
Yes, Judge, this is Attorney John.
Okay, and Mr. Shetler, if you could state your appearance for the record.
Yes, Your Honor. Travis Shetler, 4747.
All right. And we are here on an emergency motion to request court-appointed assistance of counsel pursuant to Amendment 6 of the Constitution of the United States. Madam Zhang, the court has read and reviewed your motion. I have a question that I would like to ask you first because Sir Saxs, who is the co-defendant in this case, filed a motion for standby counsel, which the court appointed last week, which is why Mr. Bateman is here. It appears, based on your motion, that you are seeking full counsel, not just standby counsel in this case.
Yes.
Is that accurate?
Yes.
Does Sir Saxs know about this?
All right. I will hear any objection from the state. I will note for purposes of the record that there was previously a phoretic canvass that was done in this case, and Madam Zhang was allowed to represent herself. And so now going back and seeking court-appointed assistance of counsel this close to trial is somewhat unusual, but I also want to ensure that the due process rights and the constitutional rights of the defendant are taken into consideration. So, Ms. Renetti, objection?
No,
If
no,
any?
I don't have any objection or appointment of counsel. At this juncture, I understand it's kind of late in the game, but I also understand the fundamental right to counsel. I did reach out to Mr. Shetler regarding his potential appointment in this case, as well as Mr. Bateman, who was appointed as standby counsel. And Mr. Shetler did inform me, and he was gracious enough to let me know that he was going to accept the appointment. And we did talk about the realistic likelihood of going to trial in a case like this with this much litigation. And both Mr. Bateman and Mr. Shetler were kind enough to let me know that this trial date probably would not be possible. And I truly appreciate that. I can understand that. Although it's frustrating from the state's point of view, I also understand the reality of things. What I would ask this court to do is, I know it doesn't appear that Mr. Saxs is present here today.
Correct.
What I'd ask to do is, I know we have that calendar call coming up, but if we could do a status check as well that day to reset the trial. I know Mr. Saxs had some discovery he wanted to still look into. And hopefully at that time, what I'd ask this court to do is, when we set the trial date, they're either going to go with standby counsel for Mr. Saxs, or Ms. Zhang is going to proceed to trial with Mr. Shetler, or for some reason she does not want Mr. Shetler anymore, that she's already been thread a canvas, like, this next court date is gonna go. But with that, Judge, I know it's a long answer to a very simple question of no, the state has no objection to the appointment of counsel.
Okay, and let me do a couple things. So I know that we have on August the 6th, because I wanted Sir Saxs to speak with Mr. Bateman first before any other questions were answered by me that were not in front of me at our last hearing last week. So my intention was to see whether or not Mr. Shetler was going to confirm as counsel today and then bring everybody back in on the 6th, since I will be back, and we can discuss moving the trial, any other issues, and then that would give Mr. Shetler and Mr. Bateman both an opportunity, and Mr. Saxs, to, speak with Mr. Bateman and get any issues, and then potentially put something on file something if there are any issues that the court needs to concern it with it prior to then, and then I can have an opportunity to look at everything. So that was my intention, was to keep that status check date for the 6th. If that works for everybody.
That's fine, and that was at 11:30, I have my notes, right?
I believe so, yes.
So yes, that should be.
And yes, Your Honor, this is Shetler. I can confirm, we did get to have a couple conversations last week,
Okay.
and the 6th is a fine. I may be in trial, but we'll work around that.
All right. So I will note for the record, Mr. Shetler just confirmed as counsel for Ms. Zhang. So he is being appointed as counsel, not just standby counsel, but as counsel for Ms. Zhang. We will keep that status check date on for the 6th of August at 11:30. And if at that time, Sir Saxs and Mr. Bateman need to do something different, we can. I will say this, to the extent, Ms. Renetti, that you said, she was previously canvassed, and now I am not inclined to allow her to fire Mr. Shetler if she decides that once again she wants to represent herself. So I will note that for the record. But if we have to cross that road, we will get to it. But I've been looking at some research on that issue, and it would be my inclination that if she is now asking for counsel, that that's fine, but that we're not going to go back on that in the future if she ultimately decides that she wants to try and fire Mr. Shetler. But we can deal with that in the future if we cross that road. So at this point, I will, if there's nothing else from anybody, any issues that need to be brought up today, then Mr. Shetler is confirmed, and I'll see everybody back on August the 6th at 11:30.
And Your Honor, may I inquire, if I could get from the court, I'll ask your staff, if I could get your trial staff so I can confirm with Mr. Shetler and Mr. Bateman before that August 6th date, so we can figure out a new trial date.
Absolutely. You all can either call my JEA and get that, or you can ask the clerk at the conclusion of today's hearing, because normally I would give it to you, but I don't have it in front of me. So you can either ask the clerk or you can call my JEA, and you all can coordinate that and try and find a spot to get you all in. I will ask, how long, Mr. Shetler, do you think that you're going to need to get up to speed? Because I will note, this is a 2019 case, and just as a defendant has a right to a speedy trial, the state also has a right to have their case tried. So how much time are you going to need?
Your Honor, I appreciate that. Ms. Zhang and I need to speak in a little more detail, but Ms. Renetti and I discussed making sure that we have a firm date that works for everybody, including the defendants, and that we'll be ready to go by then. I do think, if I recall, Ms. Renetti mentioned possibly, correct me if I'm wrong, Gina, maybe a spring area time trial date, something March, April-ish maybe, that should work.
Oh, we're pushing it out that far. Okay.
I just.
Possibly, Judge, I just don't know enough yet.
Yeah, I just need to push it to next year because unfortunately my trial schedule at the end of the year is just jam-packed and I have a firm 1-month trial in front of Judge Jones.
Gotcha. Okay.
And I do have a trial in Northern Nevada that will go in November, that'll take a few weeks. And so it seemed like that might be feasible. Of course, if it works with your calendar, Your Honor.
Okay. All right. Well, let's nail down some dates then and have some options for everybody when we come back on the 6th. Is there anything else from you, Ms. Renetti?
No, thank you so much for accommodating this for today.
No problem. Anything else from you, Mr. Shetler?
No, Your Honor, pleasure to be here. Thank you very much. And Ms. Zhang, we'll speak soon.
All right.
Yes.
Anything else from you, Mr. Bateman?
No, Your Honor, not this time.
All right. I'll see you all back on the 6th. Thank you very much.
I think this case is one of the longest sovereign citizen case delays in history. And the good thing what the judge did was like, okay, we will give you an attorney and give you all your rights, but you're not firing this attorney and that's it. So I know you were probably shocked about what was going on in this hearing, but now we're about to go back to another explosive hearing. So you know what that means. Time for your snacks and time to have a good time checking this out. Let's go.
Sir Saxs, are you there? All right. Do I have Sir Saxs on the line?
Most likely, Your Honor.
Sir Saxs, can you hear us?
I can hear you. Thank you. You had me muted.
Okay, great. There we go. All right. So we've got a couple of different things on calendar this morning. Let me go ahead and call the case. State of Nevada versus
Who is saying present?
Kimble Austin Saxs, case number C343540-2, as well as State of Nevada versus Juxia Zhang, case number C343540-1. I believe on Ms. Zhang's case, Mr. Shetler is here, so I don't think we need to have her presence.
Correct, and she is she had to go to work.
Okay.
We can seek the waiver of praise.
Okay.
I did speak to Ms. Renetti about that as long as the court approves.
Okay, all right, so I will waive her presence.
And that's the perks of having an attorney.
I think that matter with Ms. Zhang is probably going to be the shorter of the two that we need to deal with today. So why don't we handle those issues first, which would be to vacate the current trial date for her case and go ahead and set a new trial date. Would that be accurate, counsel?
I believe so, Your Honor.
All right, so what are we looking at?
We're hoping for February?
Maybe the latter part?
So
So whatever Monday was given the Monday before for calendar call, and then they'll do the central trial on this and the week following Monday.
okay, do we have, so we're in my civil in February. My civil trial starts on the 10th of February and goes through to the 10th of March. So my criminal technically starts in March. But do I have anything scheduled that is firm set in February right now? Because if I don't, then I could conceivably give you guys that.
And it does seem, I don't want to speak out of turn, but it does seem that we are pretty good at it when we want to trial, so.
Okay.
Early March, I have a firm set trial on the 24th.
Right. Me too.
That has to go. So the only way
There's actually need to prep it right up one day.
Yeah, homicide.
Yeah, it won't be, but,
Okay. But nothing.
oh no, that will be dark. Yeah, the 9th through the 16th will be dark. So yeah. Okay, so yeah, we can give you February.
That'd be great.
Do we want to give them, we can have do calendar call on the 10th, central trial readiness 11th, pull a jury on the 18th?
Yeah.
It was dark Thursday. Oh, we're not
I'm
doing
sorry.
that. So that's
Yeah, those are.
What about February 10th
for calendar call.
for calendar call? And then you go to central trial readiness on the 12th? And then start your trial on the 18th,
That sounds great.
February the 18th? Does that work?
I think that works fine.
All right. Okay,
Block out 3
understanding
weeks.
that my day, that you get basically three full days in a week.
say 2 weeks.
Okay,
Yeah, I would,
So-
based on my initial blush, I would say 2 weeks is more accurate.
okay, so if we give you the 18th through, that would take you to basically that, if we gave you the 18th through the 14th of February, or through the 7th of February, through the 7th of March,
Okay.
does that work?
Yes.
Okay, and then I have some time that following week, if we needed it for any reason, so that gives you like a week worth of buffer.
Wow, that's great. All
Does
right.
that work?
Yeah.
All right, let's do that.
Should we set it then just in case through the 14th?
We'll block it out through the 14th so that you have it if you don't need it. But that way, when we're pulling a jury too, we can say to them,
Right.
we anticipate it's going through the 14th. If you get done before that, they're thrilled. So,
That's a great idea.
all right, so we'll do that. All right. Okay, next on our, I think that covers
I believe so, Judge. Thank you.
this issue. So next we are going to the issues on, State of Nevada versus Kimble Austin Saxs.
Now the good stuff is coming.
All right, So court received a couple of things. We received an emergency motion to replace ineffective assistance of standby counsel, Mr. Bateman, along with a motion to withdraw as standby counsel for the defendant. I want to explain, well, let me go ahead and have appearances on this one first.
Yes, good morning, Your Honor. Ben Bateman, bar number 9338.
Okay.
Dear Annette, State.
And I have Sir Saxs is appearing via Zoom. And then let me explain a couple things so that we can all have this in context of what the court is going to do so that you understand, Sir Saxs, what the role of standby counsel is. Standby counsel is an attorney appointed for the benefit of the court whose responsibility is to step in and represent the defendant if that should become necessary because, for example, the defendant's in propria persona status is revoked. There is no constitutional right to advisory or standby counsel or any other form of hybrid representation. Standby counsel is there to basically help the court so that you are doing things correctly in a procedural manner, and they take no active role in the defense but attend the proceedings so as to be familiar with the case in the event that the defendant gives up or loses his right to self-representation. There is no such thing as an ineffective assistance of counsel as it pertains to standby counsel because there is no constitutional right to standby counsel. You are entitled to have counsel appointed for you, or you are entitled to represent yourself. But standby counsel, it does not serve in the capacity of co-counsel for you. They are simply there to stand by and step in if you lose your right to represent yourself. Under Ferretta, the court has specifically said that having standby counsel actually step in and take action in your case would be tantamount to removing your right of self-representation under Ferretta. And so there is none of this hybrid representation that you are asking for. So to the extent that you are asking for standby counsel to be removed based upon their ineffective assistance, that is not proper because there is no ineffective assistance when it comes to standby counsel. Now, Mr. Bateman has asked to withdraw, and it seems to me that on the basis of the fact that both of you seem to indicate that there is a breakdown in your ability to work cooperatively together, or in your misunderstanding as to what the role of standby counsel is, I am happy to allow Mr. Bateman to withdraw or for him to no longer be your standby counsel. I am also happy if you wanted him to, because it seems like you want somebody who actually is going to be able to represent your interests and do things for you. I am happy to appoint counsel for you if that is what you would like to do. But you need to understand what the role of standby counsel is going forward before the court is willing to even provide you. And we did reach out to get another standby counsel that could come in and be standby counsel. And I'm still willing to provide you with that opportunity, but you need to understand what the role of standby counsel is and not assume that they are going to represent you as the way appointed counsel would do. So that's what I would like to say in the beginning, and I will allow you to speak, and then I will allow Mr. Bateman to speak. Go ahead, sir.
I wonder what he's going to say this time.
Thank you. All right, Judge. So I object to a number of things you said, but the thing that I need to add is that when I filed the motion for standby counsel, I included the case law that basically said that they can do the other roles that you're saying. So there is the appearance of a bait and switch, not only from the case law that I cited in my motion, but also what the previous judge, Judge Kearney, got on the record. And you read that because you could see that she made the offer that they would handle things like assisting with subpoenaing the witnesses and things like that, which I am clearly not coming from a financial position to even get involved with that on any level at all. In other words, I can provide the names of the individuals that need to be subpoenaed and give some information that they would need to provide, say, subpoena duces tecum. But other than that, I need to hand it off to somebody. So if you're going to forbid the what in my mind amounts to assistance of counsel on a constitutional basis, for example, a layman would look at the Constitution saying that there is the right to have assistance of counsel. It's assistance. So I also need, you're shaking your head, but please let me finish. And so the other thing is that when Mike Agnello was the first public defender assigned to me, he was contracted out because he wasn't in the public defender's office. He's a former prosecutor from Florida, and he told me, he actually asked me at the beginning when we had our first conversation, he said, do you want to take the lead on this or you want me? I said, okay, well, you're making the offer, thank you. So I said, no, you take the lead. But he actually made that offer to me, and he was full-time counsel. So I'm saying I object to what you're saying because it seems to me there is flexibility there, and I don't see anything in black and white writing. In other words, there's no black letter law. Like even what you read this morning, that I don't know the source of what you're reading. And I mean, I can look up the case law and I can interpret it, but I would find that probably you're going to disagree with my interpretation of everything. So in order to facilitate moving forward, I will say that I will go along with, at this time, having, say, somebody who's going to be taking an active role, and then that individual and I can work it out as to what the ultimate strategy is going to be and how active I am going to take the role as far as, because I am taking the stand, I am positively testifying. In other words, I'm not going to have someone dictate to me what I can and can't do with my defense.
Well, he needs to stay out of a courtroom.
Once again, I will tell you, okay, so this is a unreported case in the California Reporter, People versus Nelson, that I was reading out of, that quotes to Ferretta versus California, that also quotes to a case called People versus Moore. So standby counsel, and I'll read you again the quote, standby counsel takes no active role in the defense, but attends the proceedings so as to be familiar with the case in the event that the defendant gives up or loses his or her right to self-representation. That's People versus Moore, 51 Cal 4th, at page 1119. Footnote.
Where was that case decided, Judge?
California.
How does California law have anything to do with Nevada law?
I will tell you how California law has stuff to do with Nevada law. Because Nevada doesn't have anything on point that says what the role of standby counsel actually is. There is nothing that is directly on point that says standby counsel does this or standby counsel does that. And so therefore, when there is a lack of case law in the jurisdiction that you are in, looking to sister states' jurisdictions, and in this case, California is a sister state jurisdiction, is appropriate. So,
All right.
so
I
let you finish, so you're going to let me finish. So, standby counsel is an attorney that is appointed for the benefit of the court, whose responsibility is to step in and represent the defendant if that should become necessary. For example, if the defendant's improper persona status is revoked. That's People versus Blair, 36 Cal 4th 686, and also Ferretta, which is a United States Supreme Court case. So you don't get the benefit of this hybrid counsel that you are talking about, where you want to run your own defense and have the assistance of counsel to serve essentially as your co-counsel. You are either going to get court-appointed counsel, which seems to me you indicated that you don't have the funds or the ability to be able to do X, Y, and Z, and so the court is happy to appoint you counsel that will step in and do what is necessary to represent you effectively, or based on Ferretta, you get to represent yourself. But this hybrid co-counsel role that you want to take is not happening in this department. And to the extent that you were given information by Judge Kearney, let me make it very clear. As I said at the last hearing, I am sorry if she said that standby counsel could issue subpoenas on your behalf. That is not the role of standby counsel. And she was incorrect in telling you that. And it is not my habit to throw another judge under the bus or say another judge was wrong, but that was a wrong statement for her to make, that the standby counsel could issue subpoenas on your behalf.
In other words, the standby counsel don't work for him.
That is not the role of standby counsel. So, I can do one of two things. Again, I can either have counsel appointed for you, or you can have standby counsel that is simply there to assist you. And assistance means that they may tell you, if you ask, how do I get this piece of evidence in, they can tell you the procedural rules to help you get that piece of evidence in. But they are not there to act as your attorney and to advise you as to what to do. So if you decide that you want to take the stand, generally speaking, that is a choice that you make, and your attorney has to abide by your decision to take the stand. So if you're saying that you've been told by an attorney that was representing you before that you couldn't take the stand, that is not their call to make. But that does not mean that they are effectively turning into standby counsel because you want to run the show. So again, you can have standby counsel that is there to advise you or to step in case your ability to represent yourself is no longer there, or you can have counsel appointed for you, but you don't get this hybrid representation that you are asking for.
All right, so for and on the record, I object to what you're saying, that my understanding is there is the rule of lenity. The rule of lenity says that if there's ambiguity in criminal statute that is construed against the author in this case, it would be basically this court and the Nevada legislature, that this is unconstitutional, that I have a right to assistance of counsel, and for this court to dictate something from California is, once again, it's unconstitutional. This is violating my rights. I had a right to get the assistance, the specific assistance I want and deem necessary, and this is
No,
completely.
you don't. No, you do not. You have the right to appointed counsel, or you have the right to stand by counsel as that role is defined. You do not have the right to have standby counsel function as co-counsel and you representing yourself. So choose which one you would like, Sir Saxs. And you can object all you want. Your objection is noted and overruled.
Sound like she shut that whole operation down.
I'm being consistent. Go ahead and get me full-time counsel, please. Thank you.
Eh? What is he up to?
Okay? All right. So. No?
The reach out to Susan Bush then.
We will need to reach out to Susan Bush then and get counsel appointed.
I was contacted, Judge, but I would respectfully decline.
All right. Since counsel needs to be appointed, we will reach out to Susan Bush.
And just to let you know, it was actually Ms. Bush's office that contacted me.
I know.
About the standby.
I understand,
But that was for standby.
but that was for standby. So, we will need to reach out and get actual appointed counsel, since the public defender's office has already declared a conflict in this case and, Mr. Coca is not willing to step in as appointed counsel. And Mr. Bateman, is, I'm assuming, still withdrawing even
Yes,
if he was
yes,
going to
so-
be appointed counsel. All right.
Excuse me, Judge, under no circumstances do I accept Mr. Bateman as appointed counsel.
Okay. All right, so we will need to reach out. So, Mr. Bateman, your motion to withdraw is granted.
Thank you, Your Honor.
We will need to reach out to Ms. Bush and get counsel appointed for you. And once we have that, we will send out a notice of hearing to have counsel confirm on the record. And at this juncture, since you are asking for appointed counsel, we cannot go forward with the trial. So the trial in this matter will be vacated and continued until such time as we get appointed counsel and can set a new date.
Question. Do you think he's doing this to delay the tactics a little bit more? Because his wife pulled off the same thing which you saw in the first hearing. Now they said she couldn't fire the attorney, but if the attorney can't get along with her, the attorney can opt out to withdraw. And I'm wondering if that's going to happen down the road. The same way Mr. Saxs is now doing it, I wonder if he's going to take the appointed attorney and then cause some type of argument down the road, and then the attorney wants to withdraw, which puts him right back in the seat after the trial gets set again. Let me know what you think about it in the comments. But if that's the strategy they have, oh, this is definitely different. Let's go back in.
Which I'm assuming would probably be the same date that we would do Ms. Zhang's. But because there has been no motion to bifurcate the cases or sever the cases at this juncture. So we will reach out and we will take this back up once we have a name for counsel to confirm. And Ms. Renetti indicated that she had something that she needed to place on the record, and so that will be the last thing that is done for today. Mr. Bateman, will you please send an order in granting your motion to withdraw? Thank you.
Thank you for the opportunity. I know Mr. Saxs has contacted me numerous times via email. He's also contacted my office numerous times. As par for the course with Mr. Saxs's communications, they can be quite demeaning, derogatory, and poignant. I elect not to respond to those emails based upon the content of those. I have on occasion responded to Mr. Saxs, for instance, when he indicated he didn't have a complete set of the arrest report. I emailed that to him. But I will not engage in a back and forth about the merits of this case. I know Mr. Saxs is now going to be represented by someone. But in order to facilitate Mr. Saxs not contacting my administration asked me to put on the record the offer in this case to resolve. I will also have a separate conversation with appointed counsel to communicate to appointed counsel the offer in this case. The offer in this case is for the defendant to plead guilty to child abuse. It is a felony, a category B felony. It is probationable, meaning so long as he is not deemed a high risk to reoffend, he is eligible for probation. The state would recommend to the court that the only condition of probation is the time in which he spent in custody, effectively requesting the court to give credit for time served. That is the offer. There is some associated fees with that plea, including a $25 administrative assessment fee, a $150 DNA fee, and a $3 DNA collection fee. That is the offer in this case.
Oh, she's definitely hot because I never heard her talk that loud. And she's putting it out there now. Take it or leave it.
I decline your offer 100%. I object to the fact that you don't answer my emails because you're a public servant. Regardless of the questions, they're legitimate questions. And that I also believe that you're so irresponsible that you have not tasked any of your investigators to look into the truthful claims that my wife and I made under penalty of perjury with the joint declaration with respect to the obvious side effects of gadolinium and Gadabis. That explains his weight loss, cachexia, encephalopathy, stiffness of muscles and joints, and the fact that you have not answered those emails. You've done nothing to basically hold up your end of the bargain, so to speak, where you're supposed to clear the innocent. And so I reject everything you've said here today.
Thank you so much.
Thank you so much. That'll be all for today.
Excuse me, Judge, when may I reasonably expect that we're going to have this hearing that counsel is appointed?
I need to reach out to Susan Bush, and as soon as we get an answer from Susan Bush, then we will send out a notice of hearing. I don't have any control over her office, and so as soon as we get the information, you will receive the information. Okay? That'll be all for today. We are off the record.
He seems anxious to want to get in touch with the lawyer, but who knows? This is probably a tactic, and I'm sure something's going to change. But you let me know in the comments if you think that something's going to change, and we'll discuss it there. So I hope you enjoyed both videos. If so, give it a thumbs up, and I'll see you around when I bring the next video.